Hello everyone. Today we will be discussing some multiple choice questions on Transfer of Property Act 1882, which is a part for your business laws. So without wasting much time, let's start with our video. Question number 1. X transfers Rs 500 to Y on condition that he shall execute a certain lease within 3 months after Y's death, and if he should neglect to do so, to Z. If Y dies in X's lifetime, option A, the disposition in favor of Z takes effect. Option B, the disposition shall not take effect in favor of Z. Option C, the disposition requires further conditions. Or option D, none of the above. The correct answer for this question is option A, the disposition in favor of Z takes effect. Question number 2. X marries Y, but in case she dies in his lifetime, he would transfer the property to Z. X and Y perish together under circumstances which make it impossible to prove that she died before him. The disposition of property in favor of Z, option A, does not take effect. Option B, takes effect. Option C, disposition is subject to another contract. Or option D, none of the above. The correct answer for this question is option A, does not take effect. Question number 3. Under the provisions of Section 29 of the Transfer of Property Act 1882, an ulterior disposition of the kind contemplated in the provision of Section 28 cannot take effect unless option A, condition is strictly fulfilled. Option B, condition is not fulfilled. Option C, only option B is correct. Or option D, none of the above. The correct answer for this question is option A, condition is strictly fulfilled. Question number 4. In case of transfer of property, if the ulterior disposition is not valid, then option A, the prior disposition is affected by it. Option B, the prior disposition is not affected by it. Option C, no such condition prevails under the Transfer of Property Act 1882. Or option D, none of the above. The correct answer for this question is option B, the prior disposition is not affected by it. Question number 5. A transfer a garden to B for her life with a proviso that in case B cuts down a certain wood, the transfer shall cease to have any effect. B cuts down the wood. Decide the case in the light of Transfer of Property Act 1882. Option A, B loses her life interest in the firm. Option B, B does not lose her life interest in the firm. Option C, no such provision is made under the Transfer of Property Act 1882. Or option D, none of the above. The correct answer for this question is option A, B loses her life interest in the firm. Question number 6. The foundation of doctrine of election under the Transfer of Property Act 1882 is that a person taking the benefit of an instrument, option A, must bear the burden. Option B, must not bear the burden. Option C, burden is not the subject of election. Or option D, none of the above. The correct answer for this question is option A, must bear the burden. Question number 7. Under the provisions of Section 35 of the Transfer of Property Act 1882, where a person professes to transfer property which he has no right to transfer and as part of the same transaction confers any benefit on the owner of the property, then option A, such owner can elect to confirm such transfer only. Option B, such owner can dissent from transfer only. Option C, such owner must elect either to confirm such transfer or to dissent from it. Or option D, none of the above. The correct answer for this question is option C, Such owner must elect either to confirm such transfer or to dissent from it. Question number 8. The rule of election under the Transfer of Property Act 1882 as applied to will is enacted in section 180 and 192 of the option A, Indian Registration Act 1908, option B, Sale of Goods Act 1930, option C, General Clauses Act 1897, or option D, Indian Succession Act 1925. The correct answer for this question is option D, Indian Succession Act 1925. Question number 9. A person is not put to his election unless he has a proprietary interest in the property disposed of in derogation of his rights. This is the subject matter under provisions of option A, Section 35 of the Transfer of Property Act 1882, option B, Section 35 of the Indian Registration Act 1908, option C, Section 35 of the Indian Succession Act 1925, or option D, General Clauses Act 1897. The correct answer for this question is option A, Section 35 of the Transfer of Property Act 1882. Question number 10. Section 37 of the Transfer of Property Act 1882 refers to apportionment by estate. In this slide, before this act, when a transfer was severed by the sale of shares in the version, the tenant was still obliged to pay the rent to all sharers jointly. Option A, any party is agreed by all the parties. Option B, unless an apportionment has been agreed to by all the parties. Option C, any two parties are agreed, or option D, none of the above. The correct answer for the question is option B, unless an apportionment had been agreed to by all the parties. Question number 11. In the Transfer of Property Act 1882, sections 33 to 37 apply to both immovable and movable property, whereas sections 38 to 53 apply to option A, movable property only, option B, immovable property only, option C, both immovable and movable property, or option D, none of the above. The correct answer for this question is option B, immovable property. Question number 12. Provisions of Section 38 of the Transfer of Property Act 1882 does not apply to cases falling under option A, contingent transfer, which is based on happening and not happening of certain events, option B, perpetual transfer, option C, Benamidars or ostensible owners who can give no title except by estoppel, or option D, none of the above. The correct answer for this question is option C, Benamidars or ostensible owners who can give no title except by estoppel. Question number 13. Section 38 of the Transfer of Property Act 1882 has no application, option A, to previous transfer where the transaction is still incomplete, option B, to succeeding transfer where the transaction is to be completed in future, option C, to perpetuity transfer, or option D, none of the above. The correct answer for this question is option A, to previous transfer where the transaction is still incomplete. Question number 14. Under Section 39 of the Transfer of Property Act 1882, the provision is made for transfer where the third person is entitled to maintenance. In this context, the court held that the right of maintenance, even of a Hindu widow, is an identified right which falls short of a charge. This was decided in case of option A, Ram Kumaru versus Ram Dai, option B, Rachawa versus Shivayogoda, option C, Ramanandan versus Rangammal, Option D, none of the above. The correct answer for this question is option C, Ramanandan versus Rangammal. Question number 15. Right to maintenance under the provisions of Section 39 of the Transfer of Property Act 1882 includes the enhanced maintenance in future to these if there has been a material change in the circumstances. This was decided in case of option A, Adivepa versus Tengavaza, option B, Kaveri versus Parmeshwari, option C, Dattatreya versus Julsabai, or option D, Pran Lal versus Chapse. The correct answer for this question is option B, Kaveri versus Parmeshwari. Question number 16. Within the provisions of Section 39 of the Transfer of Property Act 1882, the word maintenance covers also residence. This was decided in the case of option A, Kaveri versus Parmeshwari, option B, Ramamurthy versus Kanakaratnam, option C, Akoy Kumar versus Corporation of Calcutta, option D, Mehna versus Bakchi. The correct answer for this question is option A, Kaveri versus Parameshwari. Question number 17. Within the meaning of provisions under Section 39 of the Transfer of Property Act 1882, a woman is entitled to maintenance not only from the husband but also from sons who are members of joint family. This was decided in the case of option A, S. Periyaswamy versus Chelwal, option B, Raghavan versus Nagammal, option C, Chandramana versus Maniam Vankata Reddy, or option D, Basudev De Sarkar versus Chaya De Sarkar. The correct answer for this question is option A, S. Periyaswamy versus Chelwal. Question number 18. Section 41 of the Transfer of Property Act 1882 applies to voluntary transfers and has no application to option A, contingent sale, option B, perpetuity sale, option C, priceless sale, or option D, court sale. The correct answer for this question is option D, court sale. Question number 19. Under the provisions of Section 41 of the Transfer of Property Act 1882, these are some conditions. Number 1. Transferor is the ostensible owner. Number 2. He is so by the consent, express or implied, of the real owner. Number 3. Transfer is for consideration. Number 4. Transferee has acted in good faith, taking reasonable care to ascertain that the transferor had power to transfer. Option A. Only 1 and 2 are required. Option B. Only 1, 2 and 3 are required. Option C. Only 3 and 4 are required. Or option D. All are required. The correct answer for this question is option D. All of these conditions are required. Question number 20. Inaccuracy in the recitals describing the property, option A, cannot whittle down the effect of clear recitals in the documents about the property to be sold thereby. Option B, can whittle down the effect of clear recitals in the document about the property to be sold thereby. Option C, cannot depend upon the inaccuracy or accuracy of recital describing property, or option D, none of the above. The correct answer for this question is option A, cannot whittle down the effect of clear recitals in the documents about the property to be sold thereby. That's all for today. I hope you all learned something new. In our next video, we will take up some more questions on Transfer of Property Act 1882. Keep learning. All the best.